Thank you, Mr. Hibner, and thank you, Ms. Newton and Mr. Alexander, for appearing before Judge McClarity, Judge McBrayer, and me in this virtual proceeding. We will conduct your arguments today in the exact same manner as if we were all together in the Supreme Court room, and the appellant and appellee each have 15 minutes for your respective arguments. And of course, the appellant may reserve up to 5 of that for the rebuttal. And I understand you have already informed Mr. Hibner of that. Unless there's some announcements, we'll ask Mr. Hibner to call the case.
Darrell Vaulx versus Tennessee Department of Transportation.
Yes, Dan Alexander appearing for Darrell Vaulx. I did not appear at the administrative hearing, and that's pretty obvious from the record. And this is a unique kind of appeal because I agree with most of what the Chancellor Perkins, ruled in his opinion. I want to address what the Chancellor said in page 17 of that opinion. I think it's in the record in volume 3, page 442, as I recall. The Chancellor said, well, yes, this is an unfair proceeding. These administrative appeals since the Presley opinion reversing the burden of proof. He said it's fundamentally unfair, as the Chancellor characterized it. There's little or no opportunity for discovery, first opportunity for a de novo hearing. It's exasperated when a motion to dismiss, or in this case, a Rule 50 motion is made, because there's no way to test the hearsay that's introduced by that statute in the record. So I agree with the Chancellor, and he goes on to say in his opinion around page 17 of that opinion, look, it's unfair, but my hands are tied by the Presley opinion. And until the Court of Appeals, the appellate courts, I think is the way he phrased it, gives us some guidance, I can't help you, basically is what he said. But looking at it from the perspective of someone who handles some of these administrative decisions, you go into the administrative decision, administrative hearing, which is what happened here, and they introduce these volumes of hearsay, conglomeration of so-and-so said, and conclusions from that without any opportunity to challenge it. At the end of this particular presentation by Mr. Vaulx, the attorney for the department got up and made a Rule 50 motion, and it was ruled on, I think the record reflects, as a Rule 12 motion, and those are not the same motions. Now, the Chancellor dealt with that, but I think the answer to this inequity, which I submit occurred here, is to examine it for fairness. And in the Presley opinion, the Supreme Court cited in their opinion under head note 26, they said, well, look, the judge has authority to make those decisions concerning fairness. And they cite Rule 1360, 04, 01, 02, parenthesis 3. But the problem is, one problem with this scheme that needs to be corrected, either by the courts or by the legislature. I have some of these. I'm trying my best to get it corrected. And you have to start with the courts, obviously. And I think this court ruled correctly in the Presley decision. And there's no worse legislative law than a law this comprehensive that is tweaked by a court in one small aspect, and it has a domino effect. For example, I don't know, and I don't know that it's anywhere in the act or in the Presley opinion, when does an employee get to that point where he shifts the burden of proof? And the Presley opinion dealt with that. The Presley opinion in footnote 1, I think it's over on about page 17 of that opinion, said, look, we're not dealing with that today. I guess that's a hint that it's got to be dealt with, switching the burden of proof. And in that footnote, the Presley court cited to a Board of Education opinion and said, look, there we have touched on that case, on that particular issue about switching the burden of proof, but it's not before us today. There's a whole lot that wasn't before the court that day. And in other words, how are you going to pick up the pieces of the Tennessee Excellence, Accountability, and Management Act of 2012 until you fill in these gaps? When do I reach that burden of proof? To switch the burden of proof. Here, Mr. Vaulx got up twice, at least twice, maybe more, and said under oath, I didn't do this. This didn't happen. It's not true. And his testimony under oath should carry as much weight as what was introduced to that panel in the record, which was mostly hearsay, hearsay on hearsay, double hearsay, and assumptions that didn't get challenged in this case. And the reason they didn't get challenged is because a whole lot of these questions that I hope I'm presenting, and I hope are brought up before the court, of fundamental fairness in some of these things. For example, there's nothing in the law, I've got another case now, there's nothing in that scheme that would allow you to even voir dire the panel. Administrative judge ruled in a case that's running kind of parallel to this one. Well, no, you can't voir dire because the law talks about a jury, and here we have a panel, and a panel's not a jury. So in closing, and I won't take up all of my time, I've reserved a few minutes, but due process is defined in the law, I think, as fundamental fairness. This trial court has said on page 17 of that opinion, in that court's opinion, it's not fair as it is structured now. And the reason it's not fair is because that bite of the piece of legislation that the Supreme Court took out in the Presley case changed the whole complexion of the hearing. And there needs to be some fundamental questions answered. And I think one of the answers is in footnote 1 of that Presley opinion, when they talk about the Board of Education and the Cooper case it is, and it's found at 746 Southwest 2nd, 176. I'd ask the court to look at that page 17 of the trial court. Excellent Chancellor. Chancellor Perkins went into it in great detail, and I'm here on an opinion that I don't necessarily disagree with, and that's strange. But he dealt with it and said, I need some guidance from the appellate courts, and I'm bringing this case up to you. I didn't get in it early. I wasn't there for the argument. I didn't get a chance to change anything that happened at the administrative hearing. I wish I could, reading the record, but I didn't. And the judge was, and I pointed out in my brief, just overly rough on this particular employee representing himself. She says at the beginning of that, and it's in my brief, she says, I don't want any duplicate witnesses. Not going to have any of that. So what message does that send to Mr. Vaulx? You know, you can't have a witness that corroborates another witness. And that's not the role of a judge, in this case, an administrative judge. And with that Your Honors, I think I've concluded my argument. I would submit to you that Rule 50 that was made by the motion that was made by the department's attorney should not have been switched to a Rule 12 motion by the administrative judge. That's not the place of the administrative judge, but in these hearings, everything's kind of done, I submit, in a sort of the moment, especially when you don't have counsel there. So with that said, I will rest and thank you unless you have some questions.
Hearing no questions, thank you, Mr. Alexander. General Newton, the floor is yours.
May it please the court. I'm Rachel Newton. I represent the Tennessee Department of Transportation. What the petitioner has said about the fairness of these proceedings is an inaccurate characterization of the record. The record shows you everything that you need to know to make this decision. There is no unfairness in this under the TEAM Act. Everything was done according to procedure. And even if there were unfairness, which the state does not concede, it is not the place of this court to correct whatever unfairness the petitioner thinks might be in the TEAM Act. The termination of the petitioner for, among other things, theft in excess of $100,000 in state of Tennessee funds must be upheld. I too agree with the Chancellor's order. He correctly determined that the decision of the Board of Appeals was based on the law, was based on substantial and material evidence in light of the entire record, and that there were no procedural errors that prejudiced the plaintiff. In this proceeding, the burden of proof was on the petitioner. This is clear. Under the TEAM Act, in a Step 3 hearing, the person seeking to change the present state of affairs carries the burden of proof. That's not always the employee, but in this case, it was the employee. The employee was seeking to change his termination. The termination had happened. The letter was issued. He was terminated for, among other things, gross misconduct, conduct unbecoming a state employee, willful misappropriation of state funds, fraud, and for the good of the service. So when he went before the Board of Appeals, after going through Step 1 and Step 2, which affirms the decision of the department, it was his burden to show, not to disprove anything, it was his burden to show that TDOT violated a law, rule, or policy by terminating him. That's exactly what the TMA says. And he didn't meet his burden of proof, despite bringing the testimony of 10 witnesses, in addition to himself. The record shows that every witness he subpoenaed, every witness that he wanted to testify, testified, and that he also had the opportunity for redirect of these witnesses after cross-examination by TDOT, and he often took that opportunity to redirect. The instruction of the judge was never that he couldn't put on someone. She simply tried to contain the proceeding, as any good judge does. And if you go through the record, she really gave both sides a lot of allowances. She explained the process to the petitioner and what was going on. And he got all of the fairness that he should have been afforded. So just as petitioner failed to meet his burden of proof before the Board of Appeals, he similarly has failed to bring any issue before this court that would merit reversal of the Chancery Court. The standard of review for this matter is the narrow standard defined in the Uniform Administrative Procedures Act, rather than the broad standard of review used in other civil appeals. And that was noted by the Supreme Court in Presley. This court can only reverse or modify the decision of the Chancellor and therefore the Board of Appeals if the petitioner's rights were prejudiced by one of 5 statutorily defined situations, one or more. And that is if the board's action was in violation of the Constitution or statutory provisions. 2, if the board's action exceeded its statutory authority. 3, if the board's decision was made upon unlawful procedure. If the board's action was arbitrary or capricious or characterized by an abuse of discretion. Or 5, if the board's decision was not supported by substantial or material evidence in light of the entire record. And in determining the substantiality of evidence, this court cannot substitute its judgment as to matters of fact for the Board of Appeals. Now, petitioner argues that the court erred in finding he did not meet his burden of proof. But as to developing that argument, as to citing anything in the record or providing any legal authority for that, he doesn't. This court has held in Bean versus Bean that the failure to make appropriate record citations in the brief and failure to cite to relevant legal authority constitutes a waiver of this issue. This issue has been waived. There is nothing in the brief to support this argument. Furthermore, the petitioner's characterization of the so-called motion to dismiss is not an accurate reflection of the record. The record shows that a motion to dismiss pursuant to Rule 12.02 of the Tennessee Rules of Procedure was never made. And there was never a conversion to a Rule 12.02 motion to dismiss. The record shows that the hearing was held after the petitioner was afforded discovery, and there is an order in there extending the deadline for discovery for response of TDOT because petitioner had served it past the discovery deadline and he was allowed to. Furthermore, the record shows that he subpoenaed 10 witnesses for that hearing, and all of those witnesses testified, and he was able to redirect when he wanted to after that. So after the close of proof, TDOT made what they called a motion for a directed verdict. Now, that motion may have been more appropriately characterized as a motion for involuntary dismissal pursuant to Rule 41 of the Tennessee Rules of Procedure, but the ALJ's instruction was consistent with that rule. If you read the record, and this portion is cited in the state's brief and in the chancellor's order, the instruction the ALJ gave to the board was consistent with a Rule 41 motion. She did say that the motion was, quote, in essence, a motion to dismiss. She was simply explaining to a non-legal audience what was going on, that they could take all of the evidence that the petitioner just put on, they could evaluate that evidence to see if it tended to show by a preponderance of the evidence that TDOT violated a law, rule, or policy in terminating him. She also explained to them too that they didn't have to grant the motion, that they could listen to TDOT's proof as well. The record shows that the board deliberated about all the proof that the petitioner set forth, and they decided that nothing had been shown that TDOT violated a law, rule, or policy. As to these so-called hearsay documents that are submitted to the board, that the board considered, the TEAM Act not only allows those documents to be considered, it requires the documents to be considered. In the counselor is referring to the Step 1 and Step 2 documents upholding the petitioner's termination. Tennessee Code 8-30-318 requires that the Step 1 complaint and the Step 1 decision and the Step 2 complaint and the Step 2 decision be forwarded to the sitting board members prior to the Step 3 hearing for preliminary review. That is written in the statute. So even if the ALJ's instruction was error, and the state certainly doesn't concede that it is harmless error because it didn't affect the outcome of the proceeding. Petitioner got to do everything he wanted to do. The UAP dictates, and this court has noted in Bishop versus State of Tennessee Board of Accountancy, that harmless errors committed by administrative agencies do not provide a reviewing court a basis for reversal, remand, or modification of an agency's decision. As long as the necessary factual findings are based on substantial and material evidence, which they are here, the agency's decision must stand. And the chancellor understood that. Now, petitioner made vague assertions in his brief that he was denied due process of law, and he has spoken of them here. But again, he did not cite in his brief to the record in support of this claim, nor did he cite any relevant legal authority. He simply talked about the TEAM Act itself. This issue is also waived. The law in this state, as held by the Supreme Court in Presley, is that in a Step 3 hearing, the person seeking to change the present state of affairs has the burden of proof. This is not a criminal case. This is not the old Civil Service Commission. This is the TEAM Act. The burden is never on the department to show in a hearing that its termination was lawful. The Supreme Court noted that once the letter of termination is issued, there is no further obligation on the agency to sever employment. The specific words were, Nothing more is required in the TEAM Act to permanently sever the employee from its employment with the state. This is because the TEAM Act does not create a property interest in continued employment for a preferred service employee of the state of Tennessee. That is the statute, and that is the Supreme Court's interpretation of it, and that is the law of this state. So the record reflects that the petitioner received fairness all through this process according to the terms of the TEAM Act, the Uniform Administrative Procedures Act, and his termination was properly upheld. He never showed that TDOT violated a law, rule, or policy. In fact, the TEAM Act requires that the petitioner in his complaint identify a law, rule, or policy that the department allegedly violated. And he didn't do that. The record shows he didn't do that either. And he still got a hearing. So he was afforded every opportunity under the law. For these reasons, I respectfully ask this court to uphold the decision of the chancellor.
All right. Thank you, General Newton. Mr. Alexander, your rebuttal.
Mr.
Yes.
Alexander, before you get started, let me ask you about that last point that was raised. The board, when they rendered their final decision, pointed out that your client didn't identify a specific law, rule, or policy that he claimed was violated. They took the position, though, that what he was alleging, in effect, was that 8-30-316 was violated in that there wasn't sufficient cause for his dismissal. Did they get that part of it right? That was really his claim below?
I think that's correct. And in the Presley opinion under head note 1, I'm looking at now on page 18 of that opinion, paragraph 5 lists as one of the grounds unsupported by evidence that is both substantial and material. The statute requires two. I'm sorry, does that address your question?
Yes, I think so. I think so.
Okay. May I? One of the problems with this scheme as it is now, the Supreme Court said, look, we're going to see if he's got a property interest, and that affects due process of law, but the scheme itself, the statute itself, as the Supreme Court points out in the Presley opinion, says that the administrative judge can deal with fairness. It doesn't require him to deal with fairness, but what is fairness? And he can even change under the rules, and I've cited this, and it's in the Presley opinion under, I think, footnote 26, that he can even change the order of the proof in the interest of fairness. Now, the question is that something that should be left up to the administrative judge? And I'd point out one more thing in the statute, if I may. The scheme itself, the TEAM Act, requires the administrative judge to examine the pleadings up front and determine basically if the employee has met the requirement to allow the case to go forward. In other words, the administrative judge is charged with ruling on a motion to dismiss up front, and the judge allowed it to go forward. Then they come back behind and do it again after the judge has said the pleadings establish a cause to take before the board. So there's some inconsistency there, as there is in the due process provisions in the Presley opinion. You don't have it because it's not a property right, but you do have it if the administrative judge decides to exercise it. So there's a lot of inconsistency in the statutory scheme, and the chancellor, I think on page 17 of his opinion, asked for help in that regard, and I do too. Thank you.
Thank you, Mr. Alexander and General Newton, for your arguments. We will take this case under advisement. Mr. Hibner?
This honorable court is now in recess until 3 p.m.
All right.